Thank you for joining today's webinar on Secure and CARE Act provisions impacting public pensions, participants, and plan sponsors. My name is Hank Kim, and I'm the Executive Director of NCPERS. Today's webinar is part of our expanded Center for Online Learning. As I've said previously, we are all adjusting to the new normal, so we beg for your understanding and patience if there should be any technical glitches or any errant background noises. Today's webinar is generally sponsored jointly by Ice Miller and Williams & Jensen. So I'm going to begin with a few short words about both firms and our speakers today. Ice Miller was founded in 1910 and is a full-service law firm with offices in Indianapolis, Indiana, Chicago, Illinois, DuPage County, Illinois, New York, Columbus, Ohio, Philadelphia, Pennsylvania, and Washington, D.C. Ice Miller has served as tax, benefit, and fiduciary counsel for governmental retirement systems and plans for more than 30 years. Its governmental plan clients spans 40 states. Ice Miller's employee benefits group is one of the largest benefit groups in the country, which is dedicated to serving governmental retirement systems plans. It has 14 attorneys, an in-house actuary, and 2 paralegals. 7 of their employee benefit professionals focus their practice solely on government plan areas. NCPERS has been a proud supporter of NCPERS for many years. Rob Gauss, who is our speaker from Ice Miller, is a regular attendee and speaker at NCPERS conferences. He is a veteran of the United States Marine Corps and has been practicing law for 27 years. His practice is focused on governmental defined benefit, defined contribution, plan administration, compliance, federal tax reporting, and fiduciary duty for governmental plan trustees. Aside from being involved in NCPERS, Rob is also an active member of the National Association of Public Pension Attorneys, National Council on Teacher Retirement, and the National Association of State Retirement Administrators, and various bar associations. Also sponsoring is the Washington, D.C. based law firm of Williams & Jensen, which was established in 1970. It is now completing its 5th decade of operation. The firm is well known and well respected in legal and government relations circles. For the past 20 years, Williams & Jensen and its partner, Anthony Roda, have worked on behalf of public pensions. The firm has represented NCPERS for over a decade. Tony also represents individual, municipal, county, and statewide public pension plans throughout the country. He focuses on federal legislative and regulatory issues and provides fiduciary counsel and training to plans. Prior to joining Williams & Jensen, Tony served as congressional staffer in the U.S. House of Representatives. He earned his bachelor's degree in government and politics from the University of Maryland and JD from Catholic University Law School and master's in tax from Georgetown University Law Center. Thank you both for joining me and being here today. So we do encourage audience participation. And as always, if you do have questions or comments throughout the session, if you will refer to the GoToMeeting portal, there is an ability for you to send in your questions to us, and we will certainly ask our speakers your questions and comments. So we have a lot to cover today, so let's get right to it. Rob, let me start with you and ask you to talk a little bit about the Secure Act and the impact for public sector plans.
Thanks, Hank, and it's great to be with you and the NCPERS members, and it's a pleasure to present with Tony again. Amanda, if you'll go to the next slide, please. So the Secure Act, also known officially as the Setting Every Community Up for Retirement Enhancement Act, was signed into law by President Trump on December 20th of 2019. For anyone who doesn't have their calendar in front of them, that was a Friday. And you might remember that Tony and I presented on a panel at the ACE conference last year, and we talk specifically about the Secure Act, that was in May. Between May and December 20th, it was thought that the Secure Act was dead. And when I came into the office the following Monday, the 23rd, I received my pension and investment for that week. And the title headline for pension and investments was that the Secure Act was dead. So it was brought back to life very quickly and included as part of Congress's year-end spending package. The Secure Act piece is under the part is known as the Further Consolidated Appropriations Act of 2020. At the time, it was referred to as the most comprehensive piece of retirement legislation in a decade. And in just 3 short months, we've, I think, surpassed what the Secure Act did with the CARES Act that Tony will talk about. There are a number of provisions that are impactful for governmental plan sponsors. And as I talk about each one, I'll hit on the effective date that relates to that provision. Amanda, if you'll go to the next slide. So there are several areas of interest. Some are more important to our plans, our governmental plans, than others, and I'll try and talk about each. The first, and one that's gotten a lot of attention, is the later required beginning date for required minimum distributions. Prior to the Secure Act, an RMD had to be started by April 1 of the calendar year following the year the member turned 70 and a half, or the calendar year in which the member retired, whichever was later. What the Secure Act did was it changed the required beginning date age from 70 and a half to age 72. So this means that for our plans, we need to have 2 required beginning date sets of provisions and administer to 2 different required beginning dates. The cutoff birth date is for people born on or after July 1 of 1949. So if you were born before July 1, then your required beginning date age is still 70 and a half. If you were born July 1, 1949 or later, your required beginning date age is 72. And what this did is it became effective for any distributions required to be made after December 31st of 2019. And again, for those individuals who attained age 70 and a half after December 31st. It's a mandatory provision, and it affects all of the plan types that our governmental plan members and clients work with. 401A, DB, DC, 401K, 403B, 457 plans, and traditional IRAs. A related provision is, as it relates to required minimum distributions to designated individual beneficiaries. This does not apply, according to the terms, it does not apply to defined benefit plans, but it does apply to defined contribution plans, 401A DC plans, 401Ks, 403Bs, 457s. And where before the Secure Act, a beneficiary could elect to take their distributions from an inherited account over the course of the beneficiary's life expectancy, what this does is it requires those individual beneficiaries to take an entire distribution of that account within 10 years. There's a carve out for these designated beneficiaries, eligible designated beneficiaries, and those individuals are surviving spouses, minor children, beneficiaries who are disabled or chronically ill, or any person who's not more than 10 years younger than the participant. But for everyone else, they have this new 10-year rule. If you were following the news after the Secure Act, this is the provision that was getting all of the attention with regard to stretch IRAs and estate planning that was going to need to be reconsidered. It's really targeted to those DC accounts and a requirement to force people to take them out within a 10-year period of time. For governmental plans, this is effective for deaths after December 31 of 2021. So there's still time to plan for amendment and programming, et cetera, in educational materials. And one of the things we're going to have to get staff prepared for is identifying who those eligible designated beneficiaries are, and then what the rules for people who aren't part of that protected group. The next provision is the penalty fee plan withdrawal for qualified birth or adoptions. This also got a lot of attention. Before the Secure Act, in-service distributions were subject to Code Section 401A36 and plan provisions, and typically early distributions were subject to an additional 10% tax penalty. What this provision did is it allowed for a special in-service distribution for qualified birth or adoptions. It's a distribution of up to $5,000 within 1 year of the birth or adoption, and these distributions will not be subject to the additional 10% early tax penalty. There's provision for repayment of the distribution to the plan from which the distribution was made, and it's effective for plan distributions made after December 31st of 2019. This is going to require plan amendment, programming, forms, educational materials, and it does not apply to defined benefit plans, only to defined contribution plans. Then a provision that was hidden for many of us for the first couple of days while reading the Secure Act was the change in the in-service distribution age. It was included in the part of the omnibus bill that was the Pension and Health Relief to Minors Act. And when I say minors, I don't mean children under the age of 18. I mean our coal miners and other types of minors. And this provision was not passed because it was thought to be good retirement planning policy. Instead, it was passed as a way to create revenue to help pay for the shoring up of the pension and health plans for minors that were being done. So it got inserted late without any attention. It had not been discussed as part of the Secure Act prior. And what it does is it allows for in-service distributions from 401A plans, money purchase pension plans, 457 plans, all as early as age 59 and a half. This is really important as it relates to 457Bs, because the 457B rules have an in-service distribution opportunity, but not until age 70 and a half. And so this brings 457s down all the way to age 59 and a half. For 401As, it's not that much of a change. The in-service distribution age currently is 62, or at normal retirement age under the plan. And so this brings 62 down to 59 and a half. And what we now have is kind of an even playing field where, regardless of plan type, the in-service distribution age is now 59 and a half. The next provision I want to mention is the termination of 403B custodial accounts. I'll just mention it briefly. Some of our plans I know do work with 403B plans. This was a provision to direct the Secretary of the Treasury to issue guidance to provide for distribution of an individual custodial account to a participant or beneficiary upon plan termination. It's retroactive for taxable years after December 31 of 2018. And in essence, what it was addressing is that before the Secure Act, if a 403B plan allowed for investment in a mutual fund, custodial account, then it might be difficult to distribute that custodial account if plan termination occurred and the participant could not be located. So this was a provision to address a specific issue related to 403B accounts. And then a related provision to that is the portability of lifetime income investment, also particularly related to 403B plans. This allows for a plan to make a direct rollover of lifetime income investment. Think of an annuity contract or a distribution of a lifetime income investment if that lifetime income investment is no longer an investment option. This is effective for plan years beginning after December 31st of 2019. And although it affects all forms of DC plans, 401As, 401Ks, 403Bs, 457s, it really was the 403B world that this was targeted at. And the issue was that plans which offered lifetime income benefits, annuity options within investment options within the plan, often faced a concern or a dilemma related to those investment options if the plan sponsor changed record keepers. And so this allows for the portability of that investment option as you move from one record keeper to another. And then the last item of interest on this slide is that effective December 21, 2019, a plan is prohibited from making a plan loan through the use of a credit card or similar arrangement. Now, I've not met any governmental plans yet that were doing this. Somebody must have been, not necessarily governmental, otherwise they would have included it. So if you are a trustee or administrator of a plan that uses credit cards for purposes of loan funding, then you need to stop and should have stopped a while ago. Next slide, Amanda. This provision, the post 70.5 traditional IRA contribution, before the Secure Act, an individual was prohibited from making contributions to a traditional IRA once they reached age 70.5. This removes that age limit, so we can continue as individuals to make regular contributions to an IRA. This is for tax years beginning after December 31 of 2019. It only impacts governmental employers to the extent that they provide advice regarding, or not advice, they provide information regarding other types of retirement platforms, and to the extent that they maintain a deemed IRA within their various plan offerings. So they'll want to be aware of that if they do. The next two provisions, the changes for qualified disaster distributions and plan loan relief in disaster areas. Ironically, these were looking backwards, these provisions, and were providing extended relief for major disasters which had been declared by the president and they were limited in time to certain past disasters. The first provision, which allows for an in-service distribution opportunity if the plan were to be amended to allow for that, and it increases the amount to $100,000 in the aggregate for such disaster. If the plan allows for this in-service distribution opportunity, again, the individual would be exempt from the early distribution tax penalty. The next provision is related. It's with regard to plan loans. It increased the plan loan amount from $50,000 to $100,000, or even 100% of the present value of the participant's benefit. This is specifically targeted to DC plans. The increase in the loan limit availability was for loans made between December 20th of 2019 and June 17 of 2020. Again, remember that this was looking backward in time. And of course, both of those provisions now have been replicated in the CARES Act, and Tony will talk about that. And then the last item I want to mention is just the deadline for remedial amendments. As I went through each of these provisions, you noted that there were different effective dates for when the provisions became operative. Governmental plans have until at least the first plan year beginning on or after January 1, 2024 to make the required amendments under the Secure Act. In plain English, if your plan is on a calendar year, plan year, you have until December 31, 2024 in order to make remedial amendments. If your plan is on a fiscal year, then you have until sometime in 2025 to coincide with the end of that fiscal year. And Hank, those are the items from the Secure Act that I wanted to talk about.
Great, thank you, Rob, for that great and thorough presentation. Tony, did you have anything you wanted to add or any comments relative to the Secure Act?
Just two quick things. One is just in the general policy sense. What the Secure Act was, Rob did an excellent job, as expected, to outline those provisions. But it was really a recognition by Congress of increased longevity that we are all seeing, longer working careers, more years to save, and also increased retirement expenses, particularly in the healthcare area. So all of that kind of came together, and as Rob said, kind of came together at the last minute, and a little surprisingly to be enacted at the end of last year. But my sense is it's the first of major retirement legislation that we're going to see, because just with the aging of the population and the need for savings, it's going to drive this legislation. And the second thing, it's not a four corners of the Secure Act, but since we are talking quite a bit, and I'm going to start my CARES Act discussion on required minimum distributions, be aware that Congress may not be finished with the age trigger on required minimum distributions. And there is already legislation introduced, S 1431 by Senators Rob Portman of Ohio and Ben Cardin of Maryland, two that have collaborated through their whole careers on retirement legislation that would increase the age trigger to age 75 in year 2029. So I think that's going to be something that Congress continues to take a real look at. Now I'm going to shift gears over to the CARES Act, and I want to do that with a little context behind it. The CARES Act is, you could look at it as 3.0 in Congress's and the President's legislative efforts to deal with COVID-19. The first was an $8 billion appropriation, mostly for healthcare providers. The second was, and I'm sure because it's got a lot of media attention, the Families First Act. That was really COVID 2.0, which is dealing with paid leave, a very important act. And then along came the CARES Act, which is now law. And be also aware that this week in Congress, the House and Senate are expected to clear what we could call CARES Act Plus, which is additional funding for the provisions in the CARES Act. We understand it will be another $300 billion for the PPP, the Small Business Loan Program, $75 billion for healthcare providers, and another $25 for testing, which of course is hugely important. So look for that, but also realize that that's CARES Act 3.5 or CARES Act Plus, and that COVID 4.0 is still coming. Off in probably into May is another large chunk of legislation that we're going to see. So let me focus back to the CARES Act. For those of you who are interested, it is Public Law 116-136. I'm going to cover three major provisions: the RMDs, required minimum distributions, penalty-free distributions from retirement accounts, and plan loans and repayments. On required minimum distributions, if we start with what is the CARES Act, general policy-wise? So the CARES Act is a response to an emergency. It is a temporary response to an emergency, and it allows you to access retirement dollars in the provisions I'm going to talk about next. It overrides, in my view, very sound retirement policy, which is make your contributions and keep them until your retirement years. But this is a recognition of an emergency situation. Congress has gone down this road before with natural disasters. So the RMD provision in the CARES Act covers defined contribution 401A plans, 457B plans by a governmental sponsor, 403B plans, and IRAs. It is a mandatory provision, and it waives 2019 RMDs that would have been paid prior to April 1 of 2020, and it also waives any other RMDs to be paid in 2020. Of course, the corollary is that anyone who does not receive this RMD is not going to be subject to an excise tax for failure to receive this RMD. Again, it's a mandatory provision, and I'm going to state all these provisions as mandatory or permissive. And then I know at the end, Rob is going to throw in some gray areas that we could discuss that are also very important. But in general, this is a mandatory provision. The second provision I'm going to talk about is penalty-free distribution. So as Rob mentioned, in general, there's a 10% tax penalty for an early withdrawal if you are not age 59 and a half or accepted in some other way. So what you've seen as acronym CRD, which is coronavirus-related distribution, is a new exception to this 10% early withdrawal penalty. It is a temporary one. It covers 401A plans, 457B plans by a governmental sponsor, 403B plans, and IRAs. This provision is permissive. You do not have, your plan does not have to go down this road if your board does not wish to do so. It's completely optional. What it would provide is $100,000 in 2020 for such distributions. That would be aggregated by employer. So you may have more than one plan from an employer. You may have a DC plan, so you have to be aware of that. Who would be eligible for the CRD distribution? You, your spouse. If you, your spouse, dependent is diagnosed with COVID by a CDC-approved test, or if you suffer adverse financial consequences because of a quarantine, furlough, being laid off, or reduced hours, or if you're unable to work because of a lack of childcare. And the plan administrator, this is very important, can accept the self-certification of the plan participant that he or she meets one of these eligibility criteria. The distributions that you would take would be taxed over 3 years, but you also have 3 years in which to repay the distributions. This tries to run back to sound retirement policy. You know, we're allowing you to take these dollars out, but we want you to put them back in when you can. Unfortunately, that rarely happens, as we've seen from experience, but participants are allowed to do that. Questions will come up as to whether, if your plan allows these distributions, does the plan have to also allow for the repayment? Now, this same repayment type provision was in the Secure Act, the birth and adoptions distributions that Rob talked about. In meetings with Treasury and IRS, I have not seen any formal guidance from them, but in meetings, they have said, we believe if a plan, that the statute and the intention was, if a plan allows the distribution, that plan must take the repayment. And again, I think that is sound retirement policy. So I will see further guidance on that, but I would expect them to go down that road. The final provision I'll talk about, which is really two provisions, deals with planned loans. Okay. This first provision, which is your maximum loan amount, it affects 401A plans, governmental 457B plans, and 403B plans. Again, like the previous provision, it is permissive. Plans do not have to allow these new loan amounts. The previous eligibility definition that I read off on my notes applies to this provision as well. However, there is no specific statutory language that says a plan administrator may accept the self-certification of the participant, that they meet one of the eligibility criteria. We expect that the regulatory guidance will say that, but the statutory language is not there. What this new plan loan provision would do, will do, is 180 days following enactment for the period that would be up to September 23rd, 2020, 108 period, enactment to September 23rd, the maximum loan amount is now the lesser of $100,000 or 100% of the value of your account. Again, this is temporary. This is a temporary period of time in which these loan amounts have been increased. And previously, the amounts, the loan caps were at $50,000 or 50% of the value of your account. Again, this is a permissive provision. And the last item I'll talk about, which is part of the plan loan larger provision in the CARES Act, is the repayments. This is a mandatory provision, and repayments that are due from the date of enactment, March 27th of this year, to the end of the calendar year, excuse me, December 31st, 2020, are being delayed 1 year on existing or new loans. And the subsequent payment schedule is going to be adjusted accordingly. There are some questions in that that we could get into. And then the 5-year Internal Revenue Code repayment rule is disregarded for this purpose. So there are 3 key provisions. They try to meet the emergency of the moment, and also try to provide for, as in the case with the CRD distribution, an ability to repay, which of course is critical to the long view, which is your actual retirement security. So with that, I will turn it over back to Hank.
Thank you, Tony. Thank you again for that very good and thorough overview. Rob, before I ask you if you have any comments, I do want to remind folks who are listening in that if you have any questions or comments, please use the GoToMeetings portal and type in your questions for the panelists. Rob, any comments or questions or thoughts relative to the CARES Act from your perspective?
Yeah, just a couple. And Tony and I have had conversations related to this since it passed. So Tony mentions the RMD provision, and the Act says that it's specific to DC plans. I think that there's a gray area. We think that there's a gray area for defined benefit plans where the individual is, or the plan has to calculate the individual's RMD based upon DC plan rules. The good example is someone who's terminated, they aren't invested, so all they have is an account balance. And that account balance, the RMD is calculated using DC plan rules. Governmental plans are allowed to use a reasonable and good faith interpretation of the RMD rules. That's a special rule that's allowed to them. And so for plans which have a member that is subject to that DC plan rule, we think that it's optional that they could waive the RMD for 2020, but we'll be interested to see what guidance the IRS gets out in relation to that. And then the only other item I wanted to mention is that Tony's absolutely right about the coronavirus-related distributions being a new optional distribution opportunity. We think there's also a mandatory aspect to that provision based upon the reading of the text, so that if someone is already entitled to a distribution under the plan and they meet those requirements that Tony mentioned to be a qualified individual, that they could tell the plan they want their distribution to be treated as coronavirus related, and no plan amendment would be needed. For our DB plans, the best example is that the member is entitled to a lump sum distribution, either because they've separated and they're not vested, or they have a partial lump sum opportunity or option, and that they could have those lump sums designated to be coronavirus related. It would provide an opportunity for 3-year proration of the tax, the possible opportunity of repayment to the plan. And if, as Tony has indicated, if Treasury takes the position that an individual who takes a CRD should have the opportunity to repay it to the plan, but you have members who have taken a distribution of their entire account as a CRD, it'll be interesting to see how Treasury addresses that when they're no longer a member or participant in the plan.
Great, thank you. So let's move on to the next topic of, Federal Reserve's assistance, or just generally assistance to state and municipalities. Obviously, with COVID-19 and the virtually every state in some form of a lockdown, the economy has ground to effectively to a halt, which has significantly impacted the revenue stream and tax base for states and municipalities. I'm sure plans are wondering, couple that with the losses in the equities market and the potential employer contribution coming down the pike. Just let me throw it out to both of you. What are you hearing from your clients? What are their concerns, and what are some of the potential answers out there?
You want me to take it first? I'm happy to. What we've learned over the years, I think, is the best way to dig a hole for your funded status is to miss your employer contributions, and to do so repeatedly. And we've seen that in spots in the country where the funded status has been a real problem. That's what concerns me, is that we're going to have plan sponsors, for all the reasons that Hank outlined, say, look, yeah, it's in my budget and I'd like to do it, but I've got other priorities. I mean, and they would probably be able to demonstrate what those priorities are, in some cases a life and death. What I had hoped was that there would be enough flexibility in the CARES Act provisions dealing with state and local assistance that monies could be used for that employer contribution. Such is not the case. And I wish I had a better answer for the clients who have contacted me and said, you know, this could be a real problem on the horizon. We're going to see the legislation, as I mentioned, this week. It's not going to address this issue, at least as far as we can tell. And I think the vote could happen in the Senate as early as today. So we're really looking at the next round of comprehensive legislation. And there's bipartisan support for providing more flexibility for the use of these dollars at the state and local level. But that is my concern at the moment. You know, markets will hopefully rebound. It may take a while, but if you don't have the full dollars in your trust fund to take advantage of the upside, then you're digging a big hole.
Thank you, Tony. Rob, what are you hearing from your clients?
Well, it's not so much what I'm hearing necessarily that would be any different than what Tony said, but I'm mindful that I got my NCPERS news alert this morning. I think it's very interesting to watch what's happening out of Illinois, my neighbor to the west, where you have one political leader writing to the federal government asking for bailout dollars, and the governor saying that I'm not requesting that. And I think a concern amongst all of us in the governmental plans world with certain attention that certain congressmen, certain congresspeople have had towards our plans is it only takes one person to open up that can of worms, and what kind of attention that will draw if we start asking for federal bailout dollars for specific plans. It was already becoming a conversation before CARES, and the interest rate environment is so low. Will there be interest in revenue bond opportunities? There had been kind of mixed analysis of that coming into this, but depending on how long this interest rate environment is going to last, those might become more attractive to some plan sponsors.
Yeah, I think just to summarize both of you, I think there are effectively two areas that I guess plans and plan sponsors may be concerned about. You know, again, making the required or actuarially determined contribution for the upcoming fiscal year, and whether there could be any assistance from the federal government relative to plan or the plan sponsor's contribution to that. And then I guess relative to the plans and the funded status, you know, would there plans, or would there be some folks interested in sort of a federal assistance to the overall funding status? And I think you know, a lot of people are concerned relative to certainly the latter of the two, right, about plans trying to get federal assistance about their overall funded status. And while some discomfort with the former, namely, you know, states and localities getting some assistance from the federal government relative to all their priorities and using some of that money for the contribution to the plan sponsors. Yeah, I don't, you know, there's a lot of uncertainty relative to that, and you know, we shall see what the coming weeks and months you know, bear towards that. Tony, do you want to talk a little bit more about phase 4, or you know, rescue package 4.0?
Yeah, I can add a little bit to that. Of course, it's not developed, so we don't know what the four corners of it will look like. A couple things that were talked about as part of the CARES Act, actually. Infrastructure, I think, will definitely resurface in the 4.0. Over the years, we've seen various proposals designed to bring more pension dollars into infrastructure investments. Excuse me. I'm not sure if in this particular climate we're going to see that, but it's very possible. And then the assistance, financial assistance to multi-employer plans, right? Our private sector workers whose multi-employer plans have, in some cases, and it's only, I think, about 10% of the plans, but it's a tremendous amount of workers out there whose pensions are jeopardized by the situation and the funding in those particular plans. Multi-employer legislation, therefore, could come back. It also has bipartisan support, and it has real political gravitas, I'd say, in an election year, because some of the states where these workers are, Ohio and Pennsylvania and Michigan, and that's where the presidential election is going to be won or lost. So I could see those two provisions coming back into the discussion of COVID 4.0.
Great, thank you, Tony. Rob, anything you might want to add?
No.
All right. So we have a number of questions, and we have just about 15 minutes left. So let's run through some of these questions, or all of these questions, excuse me. You might have, both of you might have covered some of these questions, but I think even if you did, I think it bears repeating the answer. So we have a question about you know, the penalty-free distribution and how permissive it is. Could you guys just reiterate the penalty-free distribution under the CARES Act?
Yeah, sure. I can start with that. So again, it is in my view, a permissive and optional provision that allows a plan sponsor to amend their plan to allow a CRD distribution. And a CRD distribution would be penalty-free. The amounts would be taxed over 3 years. Again, we're looking at the ability to repay. The permissive nature of this, in my view, is that plans do not need or are not required to allow these distributions. In previous cases of hardship distributions, emergency type distributions, in my view, they've always been optional to the plan. And some plans may rush to do this, and others may, because of the way they have to amend their plan through state statute, they may not choose to go on that route. I'll let Rob pick up from there.
Yeah, and Hank, as I mentioned previously, completely agree with Tony's analysis there. We've seen more interest in adopting these distributions in the DC plan arena, in part because a lot of the record keepers took the position that plan sponsors had as little as 24 hours or 4 days to opt out of the distributions being provided, or they were going to be considered to have approved for the distributions to be allowed. Again, the only aspect that I would come back to is DB plans can be amended to allow for this. Not necessarily a good idea, but in the DB plan context, you do not necessarily need an amendment to adopt this special provision if the individual is already eligible for a distribution and would qualify for the distribution for the reasons Tony outlined. In that instance, we think that the individual could certify to the plan that they want the distribution to be treated as coronavirus related. This would not be annuity payments. This is a lump sum distribution that they're already entitled to under the plan terms.
Great, thank you.
I'm hopeful that the Treasury guidance does touch on that point.
Yep.
Yeah. Rob, the next question, I think we'll start with you. For the minimum distribution that's age 72, do we have to make an amendment to our defined benefit pension plan?
Yeah, undoubtedly you will, because your plan terms probably have 70.5 baked into them. If your plan is more general, just to say that you'll follow the required minimum distributions under Code Section 401A9, then you do not necessarily need an amendment, but you are going to need a change in programming and a change in administration. If you have 70.5 baked into your plan terms, then we're going to need to have an amendment. But again, you have until 2024 or 2025 for that amendment to be made. It's a matter, though, of operationally, before the CARES Act, operationally, we need to be prepared for this new required beginning date to affect individuals who reach age 70.5 after December 31 of 2019.
Great. So the next question, I'll just throw it out to you all. So are all participants able to delay loan payments or just the affected participants?
For the plan loan provision, the eligibility was the same definition as that in the penalty-free distribution. So it is not, you have to qualify for the new loan maximum amount and loan repayment. That is my understanding.
Yeah. And Hank, I agree with that. What the questioner might be getting at is that there was a notice issued last week by the IRS, notice 2020-23, which permitted certain deadlines for taxpayers. And one of the cross references related to that was for plan loan payments that would be due between April 1 of 2020 and July 14 of 2020. So most of us saw those announcements from the IRS and only thought in terms of our own tax filing obligations or tax payment obligations, but there were other deadlines that were cross-referenced and affected, and one of them was for loan payments that would be due during that window.
Okay. Next question. Do you know if repayments will be post-tax, or do employers need to set up additional pre-tax repayments?
The repayments are going to be post-tax, as I see the situation.
Yeah, and this is where we're going to be interested in additional guidance. It's possible that they will be allowed to be treated as an eligible rollover, and so they would come in or could come in through a transfer or some other rollover to make that. But otherwise, Tony's absolutely correct that when you bring those dollars in, those have already been taxed and are going to be post-tax dollars.
Great, thank you. Next question. If a DB plan is issuing a refund of account balance upon the termination of a non-vested member who is separating prior to age 55, and the payee qualifies to call it a CRD, Corona-Related Distribution, should the 1099-R distribution code then be 2? the numeral 2, exempt from early withdrawal penalty, question mark?
Yeah, that's a great question. Tony, do you mind if I go
No,
first?
go ahead, Rob. No, you can.
So that's a great question. If you there was guidance in the instructions for Form 1099-R that just came out in February before the world came crashing down. That was specific to qualified birth and adoption distributions, and that guidance indicated that those distributions should be coded with a 1, and that the individual that then would make representation with their tax filing that that distribution they had taken was qualified. So we don't know yet what the IRS is going to say for these coronavirus related distributions. 2 makes sense, but it's possible that the IRS will say, depending on the person's age, it's either a 1 or a 7, and we're just going to have to wait to see.
Great. Next question. If a person gets a withdrawal from one retirement plan, can they make repayments to another retirement plan? For example, a public safety employee makes a withdrawal from their city DC plan, but repays their state DC plan.
I believe that would be permitted.
Yep, that's my interpretation as well, subject to further guidance.
Okay, thank you. So we're closing up on the hour. Let me just ask, your sort of final questions, Rob. What are the 1 or 2 areas in the CARES Act that's most interesting for you?
Yeah, so the one that is getting a lot of attention is that we've heard from clients is, should we adopt loan opportunity, increase our loan amounts, because that is permissive as well, to go up to the amounts allowed by the CARES Act. From a tax code wonky side, I've got interest to see whether or not we're going to get any guidance on that individual who's in a DB plan but subject to DC plan rules regarding the RMD waiver. And I think it's worth noting that RMD waiver is, as Tony mentioned, because this is a crisis-born act, is meant to prevent an individual from paying or being paid an RMD on an account balance that no longer exists, right? If you're due an RMD in 2020, that's either based on your December 31, 2018 or December 31, 2019 account balances, depending on which RMD you're getting. And those account balances are reasonably likely to not be the same as they were on March 23rd. So I'm interested to see what that guidance is, and then whether or not, as Tony mentioned, Portman Cardin, as part of a CARES 4.0 or coronavirus 4.0, whether it takes the age out even further, because of longevity issues, people planning for retirement, all as Tony mentioned, but also possibly based upon a recognition that this may take us longer to get out of than just 2020.
Thank you, Rob. And Tony, for you, it is the year 2020. It's a federal election. Given that, what do you anticipate for the balance of the year? And do you anticipate something happening after the elections during a lame duck session?
So I think, Congress is, to say crippled is inaccurate, but a lot of their day-to-day work is not happening. Staff has been meeting, for instance, to try to keep a semblance of normality to the appropriations process. So those are 12 bills need to be done at some point by the fiscal year changes on October 1. It definitely won't happen by then, but by the end of the year or early next year. So, and there are going to be efforts underway to, I think, allow remote committee work to proceed, which we've not seen really in the history of the Congress. So I think there's going to be an effort to put some of these normal pieces of legislation on track for completion. Now, as for a lame duck session, that raises a lot of questions, of course, who wins and who loses. And I think right now, given the sensitivities and the flux of just about everything, I don't think you could say anything is a lock anymore. You know, the Republican hold on the Senate's not a lock. The Democrat hold on the House is not a lock. The re-election of the president's not a lock. So the lame duck is truly, you know, the three question marks put together. I think it could be used in any context to finish things like the appropriations process. And if we're still in the throes of coronavirus, to pump more funding into some of these programs. But I don't look for the lame duck to be a real opportunity for significant legislation at this point.
Well, on that note, Tony Roda, Rob Gauss, thank you very much to you both for this informative and well done webinar. Truly appreciate your time and expertise and insight. And also thank you again for sponsoring today's webinar by Williams & Jensen and Ice Miller. Thank you, everyone. And at the end of this webinar, there will be a short 3-question survey we ask you to answer. Thank you for joining us today, and I look forward to hosting the next webinar on Thursday entitled Portfolio Positioning During COVID-19, Market Volatility, Insights from 3 Distinct Vantage Points. Thank you all.
Very good. Thank you.